I didn't share. I do this every time.
And then I still have not yet
Good
seen.
morning. Are we ready to get started? Yes? Perfect. Okay. So, good morning. My name is Danielle Angeles. I work for EPA. I work for Loretta and the ladies at the table over there. So, we're going to be talking about treating in a similar manner as a state. Maybe you refer to as TAS for short. There are two different types of TAS. There's regulatory TAS and then FAE. So your 106 and 319 grants may also be considered TAS or also TAS. I'm not going to be talking the entire time. I tried to pass it off to Amaya. She declined. We're going to get started. Perfect. So the roadmap for today, we're going to talk about what is TAS, what is treatment in a similar manner as a state, what programs are eligible, and then we're going to talk about what are the requirements for a TAS application, what do you need in order to be approved for TAS. And then we're going to talk about a hot topic. If you were at the rulemaking session on Tuesday, I think you already had a preview of what we were talking about, and it's the 401, the revisions to the 401 rule. And then take a closer look at regulatory TAS, and we have our team members from our Office of Regional Counsel to provide a little bit more insight on jurisdiction. So what is it? As I mentioned before, Clean Water Act Section 518 authorizes EPA to treat eligible tribes with reservations to be treated in a similar manner as a state. And I know it's a very interesting term, but that is kind of what we're dealing with. So I'm not going to go through this list, but here is some of the programs that are eligible for TAS. Specifically for this one, for this presentation, I should say, we're going to talk about TAS for 303. So water quality standards for EPA to approve water quality standards, and then the water quality certification, so 401. However, if you're interested in any of the other TAS eligible programs, please feel free to contact us, and we could definitely have a discussion about it. As I mentioned, just to highlight the regulatory TAS and then the financial assistance eligibility FAE, so your 106 through 19 grant. This is a little bit difficult to see, but I wanted to highlight the number of TAS approvals nationwide for the various different programs. The number in parentheses is the one for Region 9. So number in Region 9, there are 84 tribes nationwide that have TAS for 303. 31 of them are in Region 9. So the TAS decision process is, we have gotten better. I will say, very proud of that. We have gotten better. It used to take a few years to complete the process. We have been a very well-oiled machine, and we could probably do it within a year. Hopefully, there are no special circumstances. So kind of what goes into that? We love talking to people in our program. So if you are interested, please feel free to talk to us about it. We really want to be able to answer any questions that you might have about the program, what it entails, and then also go through, what the process looks like. And that's just not a one and done. We're going to be continually talking through it with you. So you would have a call with us. We would discuss it. We highly, highly encourage you, if you're planning on submitting a TAS application, to submit a draft version first. You don't have to. However, if you formally submit an application, we'll talk about that, it requires a little bit more administrative work than is needed, right? So you would submit your application to EPA. We'll take a look at it with our partners in ORC, make sure that it looks great. And then we would provide notice to the public for 30 days. And the only thing that they are able to comment on is jurisdiction, right? They don't have to say, you know what, I don't like Loretta, she shouldn't have a program, we don't really take that into consideration. We might agree with you, but we don't take that into consideration. And I meant that for Loretta. So, you're welcome. So we provide notice to the public for 30 days. We also, if it makes sense, we might offer tribal consultation for tribes surrounding the reservation. We will then have a comment period, and that's a 30-day comment period. We'll take any comments into consideration. We'll provide those comments to you so you can see what those comments are. And then we will draft a final decision document. That is actually the longest step in the process. That will need to be reviewed internally in the region, and then it also goes to headquarters for their review prior to being able to make a decision on. Once we're able to make a final decision, we then celebrate, and then we will present, the RA will present the council or whoever chooses the certificate, and we then have TAS or 303 and 401 if that is the programs that you apply for. So what is in a TAS process? So who in the room has TAS for 106? Luther, do you have TAS for 106? Okay. 319? Really? No, that's not true. Okay. So if you have gone through that process before, then it's very similar to this. It's just a little bit more, I would say it's a little bit more, we would require a little bit more information. You need to be federally recognized. So we just asked for your name highlighted in the list of federally recognized tribes. You need to have a governing body. So that would be a descriptive statement that we could walk you through. You would need to have show reservation water. So this is really a key that may hold up your application. We need a very descriptive map that identifies the waters of the reservation and your boundaries, clear definition of boundaries. This is what, during the public notice, the public will look at to determine if you have the jurisdiction that you're applying for. And then capability, right? We want to make sure that you're running the program. You're capable to run the program, I should say. You don't necessarily need to have someone in-house at the time. We would just ask for you to say, okay, the person that's going to run the program will have these qualifications, right? So you don't actually need someone in-house. I know that's sometimes a question that people may have. Those are the 4 big things that we ask for in a TAS application. We are looking, we are here if you want to talk more in depth about any of these requirements. But we may ask for additional documentation if we feel like it will kind of move the process along. Our goal is to kind of get you TAS as quickly as possible, right? So that's my end. I'm going to have Russ come up and talk about the 401 revised rule, and then we'll have our ORC counterparts take over from there.
Thank you, Danielle. So my name is Russ Huddleston. I'm in the Wetlands and Oceans section. So in Region 9, our section, among other things, we implement the 404 and 401 part of the Clean Water Act. And so what I'm going to talk a little bit about today are some of the changes in the new 401 improvement rule that goes into effect November 27th. So a couple key things about the 401 certification program, just for those who maybe are a little less familiar with it. What this 401 certification program basically is any federal agency that issues a license or a permit excuse me, for a discharge into a waters of the U.S. requires a water quality certification before that permit can be issued. And typically this is done by states and tribes that have water quality certification authority under TAS, or in the cases that don't, my section, at least in Region 9, serves in that capacity. And so what happens is once a project proponent applies for a federal license or permit at the either at the same time or after that, but typically it's concurrent with the application for the license or permit. They will also contact the certifying authority and say, we're applying for this federal permit, we would like water quality certification. And then the certification agency decides whether or not they're going to issue certification that says that's fine, we think this project is going to comply with our water quality requirements. They may say, we think this will apply, but we're going to add some additional conditions to the permit to make sure that our water quality is protected. They can deny the certification if they feel it will not protect water quality, or if they can explicitly waive the certification, say we're just not too concerned about this, we're not going to act on it, we're explicitly waiving it. Or what can happen in kind of the worst case scenario is if the certification agency doesn't act within a reasonable period of time, but just make one of those decisions, then it automatically waivers it. So that reasonable period of time is something to be aware of. So I'm going to talk a little bit about the new changes in the rule to the certification process. So a little bit, I mentioned this before, the certifying authority, has this obligation or this responsibility to make a decision. There's another part of the 401 process, which is known as, it's under section 401A2, and that's the neighboring jurisdiction. And what that does, and I think we've mentioned this in some other sections, so a lot of this may be repetitive, but what the 401A2 does is it allows the certifying authorities who are downstream of another certifying authority. So if, for example, the state is a certifying authority, but you're downstream of that action, the 401A2 process is a mechanism to allow you to evaluate those upstream effects that could potentially affect your water quality. We'll talk a little bit more about the 401A2 process here as we go through the slides here. So one thing I really want to note, and we'll go into this in a little bit more detail, but currently the 401 certification process is tied to section 303C water quality standards. So that's the way the current process works. The new rule really sort of disentangles the water quality certification from those water quality standards. So the new regulation, what it does is it has provisions that allow tribes to just take on the 401 water quality certification role as a certifying authority without the need to establish those 303C standards. So one important thing in the water quality, the new rule, is it says, yes, you have to, if there are these water quality standards under section 303C, whether that's those that are established by the tribes, or if the new baseline rule comes in, those would apply under section 401. But it also, the new rule explicitly makes it clear that section 401 applies to any tribal water quality standards, whether they're approved by EPA or not. So if your tribe has water quality ordinances, water quality policies, water quality laws, those are covered under 401. They don't have to be specifically EPA 303C water quality standards. So your tribe, even if you don't have that, can still take on the water quality 401 certification authority. So that's a really powerful, I think, change in this new rule. So a little bit about the 401A2 process. So again, this process is intended to protect your waters from activities that occur upstream of your action. So for example, if you've got in California, in the state of the state of California is the certifying authority, and they issue a water quality certification. What happens then is the federal agency notifies us at the EPA and says, okay, we've got a permit, we've got a water quality certification for this action. EPA, you need to take a look at it and see if there's going to be an effect on a downstream jurisdiction. So what EPA does, what we do is we look at that certification and the action, and we determine whether or not there may be an effect on a downstream water quality, a downstream certifying authority. And so in order to do this, you have to be either have the task for currently the 303C standards and the 401, but under the new rule, what allows you to do is if you have water quality certification authority, or it will also allow tribes to just take on the role as 401A2. So you can be a neighboring jurisdiction and not have to deal with water quality standards or issuing certifications. And what that does is if EPA looks at a project and we said, well, if you reach out to us, or if we look at a project and we say, we're concerned that this may have an effect on downstream water quality, we immediately notify the tribes, and then you have 60 days to determine whether or not that action will affect your water quality. And if you make a will affect determination, then it requires that the federal agency consult with the tribes to figure out what do we need to do to make sure that we're not going to have an effect on your downstream water quality. It can be resolved sort of through informal channels, or if that's not possible, then it requires a public hearing. And if there is no resolution, if it turns out that there's nothing that can really be done to satisfactorily protect your downstream water quality standards, the federal agency cannot issue that permit. And so it's a very powerful tool for the tribes to really ensure that your water quality is protected from upstream impacts. So a little bit, I just want to go into a little bit more about sort of what the difference between the two are. So if you're the full 401 certification authority, what that means is that you're responsible for, under the current rule and under the proposed rule, there's what's called a pre-filing meeting, and that's the project proponent before they request a certification. They request a meeting with you and say, hey, here's our project, here's what we're doing. It gives an opportunity for some initial consultation. The new rule does provide an opportunity for you as a certifying authority to waive or shorten that period. You can, but the pre-filing meeting is kind of an important kind of component that's up to you to how you want to do that. And then once you have that meeting, once you receive a request for certification, then you have the first step is to consult with the federal agency. And this is also something that's a little bit different about the new rule, is that previously it was the federal agency who set that reasonable period of time for the certifying authority to act on that decision. Under the new rule, as a certifying authority, you can jointly work with that federal agency to set that reasonable period of time. How much time do you need to make that, to do the evaluation and to issue that certification? So that is now, the new rule really gives the certifying authorities a lot more say in determining that reasonable period of time. And if there's no joint agreement, then the default is 6 months. The statutory Clean Water Act says that the maximum time is 1 year. So the 6 months is sort of the in-between point of the maximum time allowed. And then once that reasonable period of time is set, then your next responsibility is to issue a certification decision. And typically that's either you can certify it with conditions, you can waive it, or you can deny it. And so if you are that 401 certification agency and you're doing all that, you're automatically a neighboring jurisdiction. And so you can receive that may affect notice from EPA, and then you can determine whether or not that project will affect your water quality. If you choose that, like, I don't want to go through the whole certification process and deal with having to do that and just do TAS, you can do that under the new rule. In that case, you don't have to do any of the 4 things above. All you do is, if you get a may affect determination from the EPA, then you don't necessarily, again, have to make a will affect, but it gives you that option that you can evaluate that project, you can consult with EPA, you can consult with federal agency, and figure out other things that need to be done to better protect your water quality. So that's specifically under section 401A2, and the new rule allows you to just get TAS for that, which I think is really great. So this is just kind of a quick summary. I do want to note that myself and others in the Wetlands and Oceans section are here to help. So if there's anything we can do to help you with the certification process, or if you're interested in any of these things, I encourage you to please reach out to me. I'm happy to give you my contact information. And so we're definitely here to help. So I will pass it on to Tom.
Hi, I'm Tom Hagler. I think we're actually giving it to Desean right now, aren't we?
Yes. Can everyone hear me? Am I coming in okay?
Yes, we can hear you.
All right, great. So we move on to the next slide. And I'll introduce myself as Sean Garnett. I'm in the Office of Regional Counsel, and I manage the general law section, which covers a lot of tribal issues. So I'm going to start with the background, history of TAS and treatment in a similar manner as a state. It was rooted in this idea that's articulated in our 1984 Indian policy, is that tribal governments are the primary parties for making concerning the environment within Indian reservations, in the same way that we would allow a state, to make decisions about the environment within their borders. So should, that same concept apply to tribes. And Congress recognized this idea and how valuable it would be for tribes to have their own environmental programs, to implement programs that would protect their environments within the reservations. So in that regard, Congress passed several federal environmental laws and included provisions that would allow tribes to assume treatment in a similar manner as a state. And then actually that required EPA to, come up with regulations, our own rules, our own processes for establishing when tribes have met the criteria, for assuming regulatory jurisdiction over a specific environmental program. So Congress is the one who passes the law and then tells EPA to, use the criteria that's articulated in the statute and come with like eligibility considerations so that tribes can assume TAS for certain programs. So the next slide. So one of the questions is, should a tribe apply for regulatory TAS? And that depends. It's, every tribe is different. Every Indian reservation is different. So tribes should ask themselves whether they even want to apply for TAS for a specific environmental program, and whether the tribe has the current resources or would be willing to obtain the resources to implement the environmental program. Specifically, talking about a regulatory program which takes more resources than TAS for grants. So it's really resource dependent when the tribe feels like it has the capacity, to take on that program. So next slide. Sorry, this is for Tom now. You get muted, Tom.
Hi, Tom Hagler in Regional Counsel's Office for EPA. I have my camera on just so you can see quickly that I'm not a robot, and then I'm going to turn it back off again so I don't use up all my bandwidth. This chart is showing us why should a tribe care about what's in their 303 water quality standards? It's not literally by itself a regulatory program, but as this chart shows, it drives the major regulatory programs that are under the Clean Water Act. So for your classic NPDES program on the left there, for point source discharges, those permits have to attain water quality standards. Similarly, for non-point sources, which is everything except for these point source discharges, the TMDL program, which is the total maximum daily load program, is designed to meet the water quality standards. Finally, the 401 certification process, which Russ just went through, again, gives the authorizing or the certifying agency or the neighboring jurisdiction the ability to enforce water quality standards. So it matters what those water quality standards actually say. That does not necessarily mean that you should, as a tribe, go out and adopt your own. You may take a look at, for example, the baseline standards that are being promulgated and say, okay, those are good enough. But most tribes that I've worked with, and those are the ones who have come in for TAS, have some issue in mind that they want to kind of think about specifically and with some, level of uniqueness, whether it's, mining waste coming down the river, whether it's, projects that are doing wetlands, whatever. Those all could be reasons why you may want to have your own individualized water quality standards. Next slide, please. So if you have the TAS for water quality standards, you can adopt your own standards You submit them to EPA and you get federal approval, and that's it. Then they are the water quality standards for the tribe's waters. If there is a conflict between the tribe standards and adjacent jurisdictions, whether it's states or other tribes, the regional administrator is assigned the task of trying to basically resolve that conflict between the two different regulatory regimes. I do note that there are some workload issues associated with having water quality standards. In theory and in regulation, you're supposed to do a 3-year triennial review to see if you need to change them. Even in states, that is observed in the breach, to be quite honest with you, because that's an effort. But you are supposed to have an ongoing program for making sure that the standards are the ones that you really should have. Next slide, please. Couple things. So what does it mean what do water quality standards not do? And this is a source of some confusion. It does not expand your jurisdiction. I mean, that's the whole point of the TAS process, is to show that you have jurisdiction already, and now you can do water quality standards within that jurisdiction. Also, in particular, it does not give you any direct enforcement authority. That there's a whole process that you would have to go through to get enforcement authority over things like the 401 program, et cetera. But so it doesn't actually give you enforcement directly. It doesn't deal with groundwater. It does not deal with water rights. It does not deal with fishing rights. And it does not, by the way, each of these has come up in the past with me. So that's why I'm flagging it. It does not actually determine that the water bodies that you flag in your application are in fact waters of the U.S. That is not a determination that EPA makes. That is a jurisdictional determination that the Corps of Engineers can make. So the fact that we would approve a water quality standard for one of your water bodies does not automatically mean that that's a water of the United States, as that term is used in the statutory schemes. One more slide, please. Okay, so I think this is Desean again.
Thank you, Tom. So now I'm going to get into the meaning of the reservation for purposes of TAS. And this is to note that, we consider the formal reservation to be considered the area in which the tribal governments have jurisdiction or authority to implement a regulatory program, under the scheme, but also that the tribe could have authority to regulate a certain program in areas that are on tribal trust land that are outside the formal reservation. We call this the informal reservation, and it just means that the tribes could regulate the programs on lands that are outside the reservation and apply for TAS for those lands. So we treat the formal reservation and the informal reservation the same for purposes of TAS. So next slide. And then the next two issues I'm going to get into are inherent sovereignty and congressional delegations. Inherent sovereignty is this inherent power that tribes have. They were self-governing before this country was established or before settlers came. And then the idea of congressional delegation on the next slide just speaks to Congress delegating certain powers to states and the tribes. So going back to inherent sovereignty, the idea is that tribes generally, when they're asserting jurisdiction within their reservation, that they actually don't have authority to regulate non-members. That's the presumption. They don't have the authority to regulate non-members on non-member owned land. The presumption can be overcome if there's a congressional delegation or if two exceptions are met. First, that the non-members the non-members have a consensual relationship with the tribe, either by some type of licensing agreement or contract, or that the non-members' conduct threatens the political integrity, economic security, or health and welfare of the tribe. So the health and welfare is important in the environmental context because potential environmental issues could have detrimental effects on the health of members of the tribe. And so in this regard, the Safe Drinking Water Act, we have to rely on the concept of inherent sovereignty because there's no congressional delegation for tribes under the TAS criteria, notably because the criteria that specifically addresses the tribe and the extent of their authority within the reservation really just speaks to the tribe's jurisdiction. It doesn't actually, specifically mention the reservation. So in the concept of like the public water system program, where we look at the tribe's jurisdiction, if there's non-member owned fee land within the reservation, we have to determine whether or not the tribe can assert jurisdiction over that non-member on that non-member fee land. And we just have to make a showing. It's called the Montana test, but it's the exception that, this public water system, if improperly regulated, could threaten the health and welfare of the tribe. But there is, under the Clean Water Act and the Clean Air Act, a specific congressional delegation for tribes to assert, regulatory authority over the lands within the reservation. So it's a bit different than the tribe's jurisdiction because the jurisdiction could be anything. It's not land specific, but the areas within the reservation more broadly encompasses like all land, all water, all air within the reservation. And it makes sense too, because you wouldn't want to apply different water quality standards to different areas within the reservation based off land status. That would just be a headache, a nightmare administratively to keep track of that and enforce that too. So yeah, air is the same way. Like you can't apply different standards or different, anything based off different land statuses within the reservation. So there's this appropriate, congressional delegation that EPA has, interpreted within the Clean Air Act and Clean Water Act, the actual statute. And it wasn't always this way for the Clean Water Act. Initially during the H.W. Bush administration, 91, EPA took a cautious approach and looked at the Clean Water Act and said, well, maybe, tribes still have to show their inherent sovereignty. We might change our minds in the future, but still tribes need to make this showing that, they have the authority to regulate non-members if they meet certain exceptions, like the contractual relationship or a threat to the public health and welfare of the tribe. But about 10 years ago, EPA reinterpreted its interpretation of the Clean Water Act and said, well, no, we don't need to rely on inherent sovereignty anymore. Congress specifically delegated tribes the authority to implement certain Clean Water Act programs within the tribal reservation. So we call that the reinterpretation rule for the Clean Water Act, and it streamlines the TAS process because, it makes it clear that the tribe doesn't need to meet these exceptions to regulate the conduct of non-members, non-member on fee land within the reservation. There is a clear congressional delegation. So it streamlines the process, and the tribes don't need to make this, showing, this extra showing that we require under the Safe Drinking Water Act, that they can, properly regulate the conduct of non-members on the reservation. So next slide. All right, so this is Tom now. Give it back to you.
Okay, I am back. This slide is just flagging something that shows what EPA has been working on. When President Biden came into office, literally the day he was sworn in, he signed about 37 different executive orders ordering different departments to do different reviews or different actions. EPA ended up with 48 different reviews that it had to undertake pursuant to that. And this is just a status update of some of the most important ones that I think have a pretty serious impact on tribal authority or water quality standards directly. One of them, the first one, is redefining the waters of the U.S. This was such an exciting topic that we did it twice. Actually, we did it the first time, and then the Supreme Court issued its Sackett decision, which restricted the definition of waters of the U.S. substantially. So last month, we put out a revised definition of the waters of the U.S. So that one we've done twice. I don't know if we get extra credit for that or not. Probably not. The second one is the 401 certification regulations that Russ talked about. So those are out. They will become final at the end of November. There are two more that are out as proposals. One is baseline water quality standards for tribes that do not have federally approved water quality standards of their own already. That is, like I said, that's out for proposal. I did not work on that one. I'm not quite sure what the sets of issues are there. I know this has been about a 20-year struggle to get something like that out the door. So I'm happy to see that at least we're making progress in getting it out as a proposal. And then the final one that we are working on is trying to figure out how to incorporate tribal treaty rights into the state water quality standards analysis process. This one doesn't have a lot of significance for Region 9 because we have very few tribal treaties in Region 9. And there's a lot of very sad stories that go along with that statement. And I'm very aware of those. And thank you to the tribes that submitted those stories in the comment period, because it's quite clear that there were some injustices there as to why Region 9 doesn't have treaties, period. I mean, there's a couple down on the Colorado River, but the majority of tribes in Region 9 do not have treaties. So that rule is important for parts of the country, but not so much for Region 9. Next slide, please. So what I'd like to do here is it's just a couple of issues that have been coming up over the years a lot, and try to give you an indication as to where we are on them. This one is the question of, can you, if you look at that puzzle diagram on the slide, assume that the whole thing is a tribe's reservation and that those are parcels, individual parcels. So can you get approval for treatment as a state for just some of the reservation? And the answer to that has shifted a little bit over the past 10 years. 10 years ago, I was saying, sure, the tribe can define what it wants to assert jurisdiction over, and that should be fine. I think the thinking has shifted a little bit within EPA nationally and at headquarters, where we're really trying to encourage state tribes to take over the entire program for the entire reservation. Assert your authority to the highest level that you can. Now, that said, we say that as kind of a policy preference, and I think most tribes agree with that. But there are circumstances where we are still recognizing that tribes may have a legitimate tribal interest in not asserting jurisdiction over some parcel or parcels, and we are respecting that. So it's a little tighter than it used to be, but we, if the tribe has a good reason for excluding some segment of their reservation, we let you do that. Here's some examples, and I'm not going to name the tribes, but you guys may already know this. Some tribes have contractual agreements with companies, resource companies or whatever, that say you will not regulate us. The tribe wants to respect that contractual obligation for that parcel, and we've worked with the tribes to deal with that. There's another situation where sometimes tribes have parcels spread out all over the place, and that's especially true in California, where some tribes are starting to pick up additional parcels that may not be contiguous. And they may just say, it's going to be hard and confusing for us to exercise jurisdiction over all these individual parcels. So we've recognized TIS in that case, just for the parcels that were requested. And then there are some tribes that have had parcels on their reservation that are in dispute. And they, rather than drag that dispute into the TAS process, they just say, let's exclude those. I'm not going to name any names there, but that does happen. So anyway, the short of it is we're getting a little bit tighter. We would need to have a good reason, but we will, at the end of the day, recognize partial segments for your TAS application. Next slide, please. So boundaries. One of the things you do have to show is what is the boundary of your reservation? And that includes both your reservation formal, if you have one, and also if you have only informal, or if you have additional parcels that are informal reservations. When I review these things, I always ask for your organic statute or executive order or whatever it was that created your reservation, because that sometimes gives the boundaries. And that can get very complicated because a lot of these have been changed over the years. And so, I work with the tribe to figure out, all right, what is your actual boundary? Because we need to know what's in and what's out. And I think tribes get that. So we work with that, even though it's awkward sometimes. On the informal reservations, which is a reservation parcel that's outside of the formal boundary of the reservation, but that has been taken into trust for the benefit of the tribe by BIA. I work with BIA, the land office, and get your title reports. And that helps to establish that, yes, indeed, you fit that fits the definition of an informal reservation. Finally, there are some interesting cases I've had where the boundary just is not completely known because, for example, the boundary is a meandering stream and it meanders, or the water body itself goes in and out of the reservation because of the meandering. So for those, I've actually had the tribe do a survey, and I try to avoid that because surveys cost money. But sometimes, with the consent of the tribe, we just said, all right, let's do a survey and figure out where this actually is. And so we do it that way. So boundaries can get tricky, but we've been able to work through them in my experience. Next slide, please. Expanded reservations. A lot of tribes are going through and trying to gradually pick up their ancestral homelands and add them to the reservation, either in a bunch of different ways. And can you do that for TAS? Absolutely, yes. And I've done it. You have your original TAS approval that could have been, years ago. You acquire additional parcels that become part of your reservation, formal or informal. And I would like to say that it's a lot faster the second time around. We even considered setting up a formal expedited process nationwide for doing this. We never were able to pull off the formal expedited process, but assuming everything is pretty much the same and all you're doing is adding process, it is an expedited process to bring that into the treatment as a state recognition. And that said, next slide, please. I don't know, Danielle, do you want to do this? You're there in person.
Okay. So this is just more helpful links if you had any questions. I believe that this presentation is going to be posted to the conference website. If it's not, please feel free to contact your project officer or myself, and I could go ahead and send you the links. With that being said, I think we have about 6 minutes for questions. Who wants to go first? Don't jump and if you can, please state your name when you get the mic.
Stephanie Seuss. I'm with the Chicken Ranch Rancheria. We're located in Northern California, so we're not a treaty tribe. I'm trying to, I think I heard the answer, but if the tribe has 50 or so acres in trust, and we have process going on, feed a trust on 600 acres, and we have a 303D listed creek, river, whatever you want to call it, running through that property. We have a 106 program, and I'm still not clear whether we're allowed to do baseline assessments on that because it's not in trust. And, BIA process, we're probably 2 years out right now. But I'd still, if we're looking at going into TAS, are we on, Can we get baseline? Is this informal? Is this formal?
So what I hear your question to be is, well, actually, so I think your first question was if you're able to do assessments on land that is not fully in trust yet.
Correct.
And this is a question regarding 106. I think there are some special circumstances where you would be able to. I would definitely talk to your PO about that. The rule of thumb is that if it's not in trust and not in your FAE application, approved FAE application, you're not allowed to do activities on that reservation. However, if you can show that that parcel, you have permission is one. And the second is if you could show how that water body affects waters that are on the land that is in your FAE application, I think that there is some room to kind of do some activities, but I would definitely talk to your PO about that for more specifically.
Because we have ponds and we have streams. There are springs over there that are culturally sensitive. So that's why we bought the property.
Right, yeah, and so I think based upon the FAA rules, it would need to be in your approved TAS package. However, if we can show that those waters affect the waters that are in the package, then yes. Kate, did you have, okay. I'm sorry, we could talk more about that if, perfect. Anyone else? Russ likes answering questions. Okay, well, I will give you back 3 minutes of your day, and we're gonna be up here if you wanna ask us any questions. Thank you.
Hi, I'm the organizer for the next session.
Great.
I wasn't sure, so one of my